Thank you, Mr. Chairman. I'd like to thank the ranking member as well. My amendment at the desk is about fairness. There's been a lot of discussion about fairness, so let's talk about some fairness. To quote an old proverb, what's sauce for the goose is sauce for the gander, meaning that if there's an appropriate way to treat one group, then other groups similar situated should receive the similar treatment. The Due Process Restoration Act asserts that if a brokerage firm, investment advisor, or investment company is facing an investigation from the SEC, that defendant should have the right to move their case to federal court. The bill supporters say it's unfair to delay access to federal courts for financial experts regulated by the SEC by making them go through the SEC administrative process first. My amendment states that if the defendant denies her or his clients their day in court, then the defendant forfeits the option to move their case to federal court too. If my amendment is adopted and this bill passes, the defendants would not be able to skip the SEC administrative process and move their case to the federal court if the defendant includes any of the three restrictions in his or her investment contracts with clients: mandatory dispute arbitration agreements, restrict the resolution forum of their clients, or 3, prohibit clients from participating in class action lawsuits. It's beyond hypocritical for an investment firm to demand venue choice and then require the clients to sign contracts prohibiting them from having their day in court. So let me explain what's at stake here. When an investor goes to an advisor, she signs a contract. Most of the time, that contract includes mandatory pre-dispute arbitration language. It requires investors to submit any dispute or claim to arbitration. In other words, investors who want financial advice must surrender their right to seek recourse in court or in front of a jury. These agreements are required prior to a dispute even occurring. That means investors are compelled to unconditionally waive their rights even before the facts and circumstances of a dispute are known. In arbitration, the broker chooses the venue. For example, the venue could be in Delaware even if the client and the defendant live in Minnesota. My amendment prohibits firms from requiring an investor to seek legal redress in a location not accessible to them. My amendment also prohibits defendants from exercising the option if their contracts with investors ban class action lawsuits. My amendment is supported by the North American Securities Administrators Association, and let me quote from the NASAA's letter of support for this amendment, which I'd like to submit by unanimous consent.
Without objection.
Quote, ultimately, your amendment will incentivize brokerage and advisory firms to abandon the unfair practice of forcing their customers and clients to consent on a, quote, take it or leave it, quote, basis to mandatory pre-dispute arbitration contracts as a condition of any business relationship. Your amendment will make it clear that firms that want to secure the right to have their cases adjudicated in court must provide the same option for their customers. If you support fairness for the average investor, please support my amendment. Also support my bill, the Investor Choice Act of H.R. 1098, and it has 21 co-sponsors. H.R. 1098 prohibits pre-dispute mandatory arbitration language in investment contracts. And let me share another quote from the NASAA. Quote, investors must have a choice of forum when it comes to resolving disputes with their investment professionals. Investor confidence in fair and equitable recourse is critical to the stability of the securities markets and long-term investments by retail investors, unquote. So we've had a lot of talk about fairness around here. Let's see who really means it. I'll thank the chairman and ranking member. Yesterday the SEC announced administrative enforcement action against Devon McLean and Janice Ray for running a Ponzi scheme. Yesterday, the SEC announced cease and desist orders against Qualcomm Incorporated for bribing foreign officials in China in violation of the Foreign Corrupt Practices Act. It also fined Mr. Craig Salome about $15,000 for trading on insider information when eBay bought GSI. It barred Joseph Giordano from working in any investment job because he made material false and misleading statements to investors. In short, yesterday, the SEC acted through its administrative procedure process, which does include substantial due process to protect investors. And the day before that, and the day before that. Well, they don't always get it right, but the answer certainly is not to gum up the process to the degree that no action can take place within a reasonable amount of time of the offense. In fiscal year 2015, administrative law judges issued 207 initial decisions, held 27 hearings, and ordered civil penalties totaling more than $20 million. All details are posted on sec.gov. Is there anyone, there on that website, anybody can see that the SEC Commission staff do a lot of work to ensure that people in the financial industry have to follow the law. The administrative procedure process is of critical importance to investor protection and to fair, transparent markets. But I don't think this bill today recognizes that. This Due Process Restoration Act will weaken the SEC's ability to keep bad actors from ripping off investors. This bill gives defendants the ability to shop their venue, to avoid cease and desist orders or fines, and to seek out a more favorable venue and more opportunities to delay justice. This bill allows them to avoid appearing before an administrative law judge by going straight to federal courts. And current law allows anyone the right to appeal the judge's ruling to a federal appeals court if they wish. I don't think the current administrative proceedings process is unfair or abusive. It's a delay this bill represents a delay tactic, and I think it should be rejected by members. They know that the federal courts are already under-resourced and overwhelmed. And that in part of the delay is because the Senate refuses to confirm qualified candidates. Nearly a dozen federal district court nominees await votes on the Senate floor. In fact, even the Supreme Court nominee, I think, is going to be delayed because of political chicanery. There are 25 judicial appointments pending in the Judiciary Committee. So sending these cases to federal courts, and a quick review of the SEC's website, we'll see a lot of these cases, is just a way to delay the day of reckoning for people who deserve to be held accountable. This lets fraudsters continue to rip off unwary investors until their day in court comes, which could be 10 years or later. So yesterday, 11 states held presidential primary elections. A strong message from voters in those states was belief that the game was rigged to protect the powerful. This bill is a powerful example of how Wall Street and the financial services industry, with the aid of members of Congress, can rig those rules to the disadvantage of the small investor. Now, we don't need to slow down or gum up the SEC. There is substantial due process in the process already, and we should be acting aggressively to strengthen the SEC's enforcement activity, not weaken it, so that we can restore confidence to investors who enter the investment world warily because they fear that nobody is going to protect them. We should stand with Main Street and oppose this bill. And I'll yield back, balance of my time.